Good morning. Welcome to our Business Festival this morning. We are on the Wednesday of our Business Festival, so day 3. And I'm delighted today to have Anoop with me from Quest, the Senior HR Advisor. She's going to be doing tomorrow's workforce, the challenges faced by employees. You will notice that at the bottom of your screen there is a chat function. So if you do want to ask any questions throughout the whole presentation, it is an interactive presentation. So Anoop is happy to take questions at any point, or at the end should you wish to do so. That's not a problem at all. Could I just ask that during the presentation itself you make sure that your mics are muted, just so we can all hear Anoop clearly. And Anoop, it's over to you.
Thank you, Laura, for the introduction there. So my name is Anoop, and I will be holding this seminar today to focus on the potential challenges that employers will be facing. So just a brief introduction to myself. I've been on the HR advisory service for a number of years at Quest as well as other businesses. So I have an all-rounder knowledge in terms of employment law, ranging from grievances, disciplinaries, attendance, mediation. So all this information is pretty much hot topical that we're getting on the advice lines, which is quite important for you to understand to make sure that you're getting it right. The topics that I will be focusing on today will be 8 areas which are quite popular at the moment. So the first thing is returning to work. The second being testing and vaccinations. Number 3, hybrid working. 4, lone workers. 5, the impact of long COVID. And 6, with the imminent return of children to schools, returning back to work, and holiday issues, that will also be covered. And finally is the topical issue of avoiding redundancies, particularly whilst people are now going to be coming off furlough. So what we're getting a lot on the phones at the moment is the issue of returning to work. Employers are very conscious about the fact that they don't really want to go against government guidelines or health and safety guidelines, and they are stuck in a situation where they are looking to bring employees back into the workplace. Now, a number of employers are struggling with that because a lot of employees are posing difficult questions, which questions the employers. Can we actually force employees back into the workplace? The underlying reason is yes, you can. As an employee, they're governed by a contract of employment, so it's very important that the employee is adhering to their contractual obligations. So from that perspective, it's a reasonable instruction for an employer to ask the question that we wish you now to return back into the workplace. Failure to return back to the workplace could be interpreted as a breach of contract. Now, what that essentially means is not to go straight to an instant disciplinary, but there is a procedure that an employer needs to follow to ensure that the employees are returning back onto the workplace in a reasonable basis. So if an employee is really argumentative and not wanting to return back to the workplace, it is up to the employer to put together a written plan. Now, that plan is important that they consult with employees that employees are now returning back into the workplace, number 1, and number 2, that we are following health and safety guidelines in line with Public Health of England as well as the government guidelines to address the issue of COVID. Now, many of your organisations would already be adhering to those guidelines, for example, social distancing, as well as sanitising, hand sanitisers, face masks. So from that perspective, if the employer is continuing to do that, then there's going to be less of a breach. So from that perspective, it's just to make sure that employees are aware that they are following those guidelines. And from that perspective, that as long as from a health and safety perspective, we are following that through, everything is okay. Now, from a health and safety perspective, it is important that we do follow statutory duties to make that workplace a safe working environment. So in line with what your health health and safety advisors are probably already doing, or even HR advisors, is to carry out a suitable risk assessment within the workplace. So from that perspective, that would have already been covered. The second thing is to make sure that you're taking reasonable, practical steps to minimize the risks of the spread, which you're probably already doing in order to follow those guidelines as mentioned on Public Health of England. So we're looking at providing adequate ventilations, windows open, clean more often, sanitizing. So once we've gone through that, it's just a matter of following the processes through. Employers are liable for anything that does backlash on them. So you should consult with your employees with a fair, reasonable paper trail, whether that's through your own policies or whether that's through a letter or a memo, so that the employees are aware that the employer is following this through on a serious level. It's useful to know that breaching government workplace safety guidelines, you could face a potential claim from an employee. Now, what I mean by that is if an employee could state that I caught COVID at work because my employer was not taking the situation seriously. In these serious situations, the employer could be liable, but only if the employer could prove, or the employee could prove, that the employer was negligent. So again, as I've mentioned, follow your processes, your procedures, COVID-19, and make sure that everything is on a reasonable level. On another scale, it is difficult to prove that you did catch it at work. However, you need to ensure that your policies and your procedures and your backups all pretty much show that you've done everything reasonable in that timescale. So that exposure to COVID could have been picked up outside work, but from inside work, the employer is liable, so they do need to follow that as a rule. Now, it's the situation about vulnerable employees returning back to the workplace is also another issue, particularly with staff who had been shielding for a long period of time. Now, what that means is that if a vulnerable person had been told by the GP that you must stay at home because of the shielding and you're more likely to catch COVID. Now that was actually eradicated on the 1st of April. It's no longer in existence in terms of shielding. So it's up to the employer to make sure that they are following protocols to ensure that the workplace is adequately safe. But this would potentially move on to the next subject, which is hybrid working, which I will come on to as potential options. So another question that we're getting a lot on the phones is about testings and vaccinations. So we're looking at lateral flow testings. Where do we stand? Vaccination, can you force employees to have them? Or do you pay employees to take time off to take these jabs? Now, the government have made it absolutely clear last month that the testing of the lateral flow testing is voluntary, and therefore, as a result of it, it's best to convey to your staff it is advisable to take it twice a week, as I do, to make sure that I am free of COVID and I'm not going to be bringing in COVID within the workplace. So from that perspective, lateral flow testing is an optional issue. However, I'm sure that you're aware with the recent news from the government about care homes, that from November it will become mandatory that you do have your vaccination, the 2 jabs. Now, it shows that if it is mandatory, and it will be in some organisations to have the vaccination, you need to have a compelling reasons to advise why you need to have it. So in the case of care workers, the government are reflecting on this and putting it in place, and it will be a compulsory mandatory item that you must have. Just the other day, I was on the phone to a client who had an engineer who was going to care homes, and the care homes had already implemented in place the vaccination, and therefore the engineer was advised that you must have the vaccination in order to get your job done. The engineer stated, I do not wish to have the vaccination. The employer stated, we have no other place to put you in because you've been doing this job going into vulnerable places. They're not prepared to have you in there. So that potentially led to an SOSR termination with consultation and discussion because the individual felt quite strongly not to have the vaccination. So you can see the knock-on effects by not having the vaccination as such. So it's important that we do make it clear that the employee understands the knock-on implications. Employers cannot force the employee to have it because under human rights, it is their sort of duty to think about what they want to do, but it is their choice when the employer does have a compelling reasons to have that vaccination in place because of the clients that they are potentially working with, vulnerable employees. Now, a lot of these vaccinations happen at different work times. So you're looking at midday, tea time, 11 o'clock, whilst the employee's at work. Now, the bottom line is the employer does not have to advise the employee to take time off for the vaccination. So it's a optional situation. So the employer can say to the employee, you do not need to take this time off right now, take it at the end of the day. However, I am prepared to pay you to do it because we're in a pandemic. It's advisable that we do get this vaccination done. So it's an option for the employer to pay it, which most employers are doing, or whether they want the individual to make up their time. But that's something to consider because we are, again, in a pandemic. So the next question of hybrid working, which is extremely topical at the moment, we're getting a lot of calls on hybrid working, how to make it work for the employer and the employees and the difference between flexible working. Now, the hybrid working is a new thing that's come out during the pandemic. It's an opportunity for employees to work from home and protect themselves, particularly from shielding employees, as I mentioned earlier on, as a good option. And it's referred to as the term as hybrid working. So during the COVID pandemic last year, we saw a rocket number of people working from home and no longer in the office. In fact, the office looked a bit of a graveyard because nobody was in. But it did prove to a lot of employers that working from home does work. It has been very successful in some industries. I appreciate that not all businesses are catered for this. For example, factory workers, pretty much people who are out there doing stuff in the NHS, in fire brigade services, it's not a work from home job. But for office workers, it has worked out pretty well. So employers need to think about how we can move forward, because Chris Whitty did kind of hint that during the winter period months this year, COVID will again potentially spike. So employers have begun to think about putting a hybrid working policy into place. If you are struggling with that, we do have policies and procedures that are available for you to use. So employers have realized that these work-life changes, or working from home, working in the office, is actually really good work-life balance. It's creative from the feedback that we're getting, is a happier workforce leading to really good performance levels and a reduction in sickness absence. So it has had a very good improvement on businesses in that respect. So what the employer needs to consider when putting this in place is, number one, to consult with your staff. Number two, you need to put a policy and procedure into place. Number three, you need to look at privacy. So it's very important we look at data protection, privacy, cyber security. And number four, you're looking at risk assessments. Now that would be part of your policy, and the employer or the manager or team leader would be able to communicate to their staff, this is what we're anticipating in doing in terms of data protection to ensure that the work that you keep on your laptop is protected. And then lastly, we're also looking at how this would impact under the flexible working regime. A lot of employees have put in requests for flexible working, which means that we're looking at reduced hours or days to fit their own family work-life balance. If you are looking to go into flexible working, the gov.uk have a really good sort of form there to go through from the employee and the employer, as well as we do, but it's a matter of going through a consultation if you are looking to reduce the number of working days and as a permanent change. A lot of employers have considered this because COVID has had that much of an impact that there is simply not a one-time full-time equivalent work available, so they've reduced it to maybe 70% or 50%. So from that perspective, it's a matter of if the employee has a domestic change at home and they wish to make an application for flexible working, then that would be considered under the flexible working policy. So hybrid working is working from home, flexible working is change of hours, change of days to accommodate their own family domestic arrangements at home. If you do decide to incorporate the hybrid working, this will have an overall impact on contracts of employment moving forward. So you may wish to write addendums or even a variation to terms and conditions of employment to ensure that you have written confirmation in terms of their permanent situation given the impact of COVID. Now, as you are working from home 100%, 90%, 50% of the time, it does actually fall under the definition of lone working. So we need to understand this and make sure we're following it from a health and safety perspective. So from that perspective, the Health and Safety Executive defined lone working as those who work by themselves without any close or direct supervision. So you're looking at industries such as security guards, workshop, factories, where they're working 24 hours of the day and are lone working, or even potentially an office worker working different hours alone at home. The employer has an obligation to ensure the health and safety and welfare of their staff. So it's good to have a lone working policy too, which would cover any sort of detrimental impacts that could happen to the employee. So for example, if there were accidents, slips, trips, fall, illnesses where the lone worker faints, what do you do? So you need to have these kind of provisions in place where there's emergency number, mobile number, buddying system, so that this is catered for, because what you don't want to do is to leave it alone and nothing is done about it. This sort of brings on to the case of the Susie Lamper case disappearance as a classic example. This lady, back in the 80s, was an estate agent who went missing in 1986. She went out to meet a prospect buyer to view a property. As a lone worker, she went there, got to the property, was ready to view it with the potential client. But what had happened is she never returned back to the office. To date, nobody knows what happened to her. She just simply disappeared. As of today, 2021, the case remains unsolved, and that is potentially a very high risk as a lone worker. So from that perspective, employers have a statutory duty of care towards these lone workers to safeguard their safety and to ensure reasonable control measures are put in place to avoid any risks or to minimize it. So the employer's got a responsibility here. So what the employer needs to do if they are going to be introducing the lone working policy is to create a policy to ensure safety culture is paramount, reporting procedures, relevant contact details, provide training and instructions to staff in this. We must update next of kin and family details, numbers and contacts. So it's important that we get this all communicated and done in that perspective. So there's also the issue of personal protection, such as alarms to be worn, provisions of additional equipment, mobile phones in emergencies, and as mentioned before, introduce a buddy system. So from that perspective, the employer's got an obligation to follow a risk assessment for lone workers, clearly identifying the risk and what the employer is doing to mitigate as much as possible. So moving on to the next slide, the effects of long COVID. As you are aware, long COVID occurred almost 2 years ago around the world. However, the effects of COVID has had a devastating effect, particularly within the UK and the workforce, as it has done in the world. Now, it's important that employers understand that long COVID could be considered to fall under the definition of a potential disability, which could be a risk to your business if not dealt with in the correct manner. Now, what that essentially means is that the individual, normally government guidelines is 2 weeks. That's how much you need to isolate to make sure that you're free of COVID, but it may still be in the system. But we have heard news of people who have had COVID for such a long period of time that have had a detrimental impact on their health. Now, under the definition of disability under Section 6 of the Equality Act, it states having a physical or mental health impairment that has a substantial long-term adverse effect on the ability to carry out normal day-to-day activities. Now, with long COVID, that could have a potential detrimental impact where it actually escalates for a long period of time. Now, we don't have today any cases from a tribunal where it is deemed to be a disability. However, we are able to rely on similar cases that have demonstrated where it may fall under the definition of a disability. So the case that I'm looking at is the Chief Constable of Dumfries and Galloway Constabulary versus Adams. Now, this case was based on an ME sufferer who suffered similar symptoms of COVID, which is persistent long-term sickness, for example, poor respiratory system, shortness of breath, chest tightening, and heart failure, all the similar impacts of COVID. And it was deemed as an outcome and concluded that this person, Adams, was indeed deemed to have a recognised disability, and therefore it was protected under Section 6 of the Equality Act. So employers got to really get to the grips of this COVID pandemic, and they must adapt to the ongoing situation. But if in doubt, do give us a call on the advisory assistance line where we can assist you with these queries. So normally what tends to happen in these situations, the employer is kind of bound by doctor's report and GP reports, where we are looking at a phased return back, home working, adjusted hours if they may, or if they can essentially come back into the office at all. So you've got to talk to an expert when you are dealing with the effects of long COVID, particularly within the workplace. Next slide, just one moment. Right, holiday issues. Holidays has been quite popular again. Employees are now starting to travel abroad, and employers want to know, can we talk about relevant issues? For example, refusing permission to go on holiday. Can we ask where they're going? Is it a red zone, amber zone, green zone? And potentially with the ongoing situation of holidays accumulating from last year, and employees having 30, 40 days annual leave, can we insist staff take their annual leave? So these are very important fundamental questions that we need to address, because the employer needs to take control of the situation. Oh, sorry. So the first one, can we insist employees take their annual leave? The answer is yes, you can as an employer. Under the working time regulations, there is a statutory default position that the employer can insist that the employee takes holiday. However, it works on the basis of the twice as much notice. So, for example, if you want an employee to take 1 week holiday, you, the employer, must give 2 weeks notice. If the employer wishes the employee to take 2 weeks holiday, the employer needs to give 4 weeks notice. it is enforced and therefore the employer can force it potentially. However, what the employer can do to be amicable is to state to the employer, we are now allocating holidays. Unless you come back to us ASAP, we will start to allocate holidays. It's important that you do communicate this on email, memos, so you do have a documented paper trail to support this. Once you have, then you can enforce it. The next question is, can we ask staff where they're going on holiday before we approve their request? Yes, you can. However, you may want to update your policy and procedure given the COVID pandemic. We need to be aware of where you're going and the potential impacts. So if a person is going to an amber zone that subsequently switches to a red zone and they come back and they have to isolate, then there's got to be periods of times that we have to take into consideration, or even if the individual comes back with a positive COVID case. So it's a matter of the employer rearranging their duties to ensure that they can do everything possible, unless the employee can work from home on their laptop. So that's something that you do need to consider when you are considering this. Can you refuse permission? The answer is no. What an employee does in their own time, in their own accord, is up to them where they want to do. You cannot normally dictate employees what to do in their own time, much less where they can go on holiday. So you can't really refuse that. So bear that in mind. However, what you can do when you are enforcing the policy is to make sure that if we are told where you are going, then we'll be able to go follow the government guidelines. This could potentially mean quarantining afterwards, so that you're able to sort of keep that into account. As you're aware, from August the 16th, fully vaccinated people will no longer have to self-isolate if they are in contact with a positive person. So what that essentially means is that if you are sitting next to a person who is COVID positive and you've had both your vaccinations and you're negative, you do not need to isolate. The government have been changing guidelines on this quite frequently from that perspective, and therefore as a result of that, it's a matter of just following the gov.uk guidelines and see where that goes. If you do have COVID, naturally, yes, you must isolate and follow the rules of 10 days as such. In that perspective, so it's important that we do sort of follow the gov.uk rules in terms of that. Returning to school. Now, this is a very important one because the rules have changed quite a bit from schools, and now they're introducing vaccination for children as well. That's a discussion as well. So we need to make sure that when schools, and some of them have, majority of them have opened up, it will bring isolated incidents of children catching COVID. And if children do catch COVID and the schools advise that that particular class of children must go back home and isolate, depending on what's the situation, how difficult it's been in terms of COVID, we do need to follow those. As a parent, either work from home, or the rules under the Employment Rights Act, section 57 states under emergency dependency leave, you can take time off as whether as holiday or unpaid. The employer's got to get to grips with it, that this is the reality. We are under a period of a trial period now that schools, children have returned back. What can we do in order to enforce that the employee is able to care for their child? In terms of sick pay, before different rules applied, but now the most recent updated government guidelines are now stating the only person, if somebody needs to self-isolate, they will only need to do so if they have coronavirus, if they are not fully vaccinated and someone in their household has symptoms or tested positive for COVID, or have been told to self-isolate by NHS track and trace. If in doubt, I do tend to rely on the NHS 111 number. Please do talk about the symptoms or the situation with them, and they're able to give you some more clear guidelines in terms of that. So from that perspective, we have to be mindful of that. However, as I mentioned before, if you've been double jabbed, somebody's been positive in COVID, they do not need to self-isolate. So we've just got to watch the sort of radar in terms of returning to school, how it works out, and with the government introducing jabs for children of school age as such. Right. And finally, we've got redundancies, very, very topical, because a lot of businesses have been relying on the furlough scheme and paying what they can to their staff. But as a result of this, unfortunately, the dreaded situation is that, particularly in the travel industry, that which has been hit hard, is what can we do to avoid redundancy? What can we do to support our staff? Now, there are other options available for you to consider. In your contracts of employment, there is a layoff or a short time working clause. If you do not have it, you have to consult. What this clause essentially means is if there is a lack of work, but there is hope that work will increase in the coming months, the employer can ask the employee to reduce their working days or hours, or not to come in for a short period of time. So if we're following the layoff or the short time working, it's normally 4 weeks in a row or 6 weeks in a 13-week period. So we need to make sure that we are following the guidelines. But if it's anticipated that this will be going on for many months, then the layoff and the short-time working clause is really just a short pit stop. What you would need to be looking at is reducing working hours permanently. Now, what that means is a lot of businesses have already forecasted over the next 12 months workload with less and less work coming in. What can we do? So instead of a full 40-hour week, employers may want to permanently reduce it to maybe a 30-hour week. However, on the assumption that we will be reviewing the situation on an ongoing basis to ensure that when work does pick up, it could potentially change back into full-time work. The next thing is that a lot of employers are considering recruitment freezes. So as part of a restructure process, businesses have already put unavoidable costs to the business. So by doing that, they've actually considered letting temporary staff go and freezing recruitment until work picks up. So it's a matter of reviewing what the working situation is within your business. Secondments. Funnily enough, I had a call the other day. Within the pandemic, a lot of businesses that have been suffering have sort of followed the secondment route. So where one business has been particularly doing not so good, they've actually loaned their staff out to other businesses who are absolutely thriving in work and supporting other businesses and working. So it's a brilliant sort of situation to ensure that the staff is actually getting additional money or sort of some kind of income coming in. So you have to look at the bigger picture, review the situation, see what fits for your organization. But whatever you do, you have to consult with your staff, followed up with a paper trail, because at the end of the day, what you don't want is a constructive dismissal claim because you haven't consulted or have gone through a relevant paper trail in that sort of basis. Oh, right, that's the end slide. Right, so we've now come to the end of the presentation. Does anybody have any questions? Has anything come through, Laura? Any questions?
Anoop, that was fantastic. Thank you so much. Took a bit of a while there for my video to come back on. Just having a look if there's any questions in the chat. There doesn't seem to be, but if anybody's got any questions, there's two ways you can do it. You can either pop it in the chat right now, or you can ask it directly if you want to unmute yourself and pop your video on. If you don't feel comfortable doing it in this session, I'm sure Anoop will be available to ask any questions with her email address in the chat, if that's okay, Anoop.
Yeah, if you've got any questions and you're part of the Quest service, do give us a call back on the advisory service telephone number, where we have an ample amount of advisors who'll be able to advise.
Perfect. Thank you so much. I'm just going to give you another couple of minutes just in case there is anybody. I know you covered a lot of topics there, Anoop, so there's quite a lot of information to take in, which is absolutely fantastic. So thank you so much. Anoop, are you okay to just stop sharing your screen just so I can share mine? Would that be okay?
Absolutely. I'll just come out of that.
Brilliant, thank you very much. Just for all of you that have attended today, I'm just going to be sharing a QR code just on the screen now. And this QR code basically just lets you, if you just hover your phone over the top, you will be able to pop any feedback about the webinar for today, just in your phone. And it is literally a 2-second job. There's only a couple of questions that you need to just pop in there. I just want to thank you all for being here today. And like Anoop said, you can contact the Quest helpline at any point, and we will be making sure that we give those details at the end of the session as well. And for those of you that have, this is your first webinar on the Business Festival this week, we are doing a range of Business Festival webinars tomorrow as well. And we have done some on Monday and Tuesday, which are on our webinar library. So if you are looking to look at any of them that you've missed, you will be able to do that on our catch up on our webinar library as well. Anoop, thank you so much for today. Really appreciate it. Is there anything else that you would you like to say before we end today's session?
No, that's fine. I suppose one of the feedback things that we could ask is if there's any topical issues that you would like us to run, please do let us know. We're more than happy to look into that for you.
Fantastic, brilliant, really appreciate it. Like I said, everybody, thank you very much for this morning, really appreciate it, and hopefully we look forward to seeing you on some of our other webinars later on in the week. Thank you so much. Bye now.
Thank you. Bye.
Bye.